Ravi sir, please proceed.
Okay. Dear doctor friends, good afternoon. On behalf of my organization, the Institute of Medicine and Law, I extend a warm welcome to all the online viewers attending this webinar for creating awareness on a very important topic for the healthcare providers, which is a doctor's legal right, protection from police case. Many of you may wonder and may even have the question, why do I need to know law? How is it relevant to me? After all, I have studied medicine. I am a qualified doctor and not a quack. But believe me when I say this, and I say this from experience, that every doctor must know certain laws. I am not suggesting that you should join a law course, but you also need to understand that ignorance of law is not an excuse in court. First, you need to know those laws which are useful in your day-to-day practice and which will help you in minimizing the chances of medical errors. The second part, which we are going to cover in detail today, are your rights and privileges, which will help you in dealing with the police in cases of criminal proceedings against you. The healthcare sector and the pharma sectors are growing at a very fast pace. Yet, while you are continuously updating yourself on the advances in science and technology, are you doing enough to keep yourself updated on the ever-changing laws of the land? While laws and regulations in other domains, in other businesses or professions, may not have a deep impact, but please understand, when it comes to healthcare, even minor non-compliances could have terrible repercussions, leading to an increase in incidents of violence against doctors and in cases being filed in court across the country. Unfortunately, a doctor in Rajasthan committed suicide because of the harassment by the relatives of the patients and because of the wrong charges applied by the police in this case. We firmly believe that what happened would have been easily avoided had the doctor known about the Jacob Mathew case decided by the Honorable Supreme Court way back in 2005. And the special and unique privileges and protection that it offers only to the healthcare community and to no one other than the doctors. Today, we will discuss this specific case and explain the various sections of law which are applicable in cases of criminal proceedings in detail, together with the special protection that is available to you thanks to the Jacob Mathew judgment. While nobody can reverse what has already happened, it is our earnest desire that it should never, ever be repeated again under any circumstances. This webinar is but a small step in that direction, and we will sincerely try our best and use our resources to ensure that this shocking incident is never repeated again. But we will not be able to do it alone unless you, all the doctors, the doctor groups, and the doctor associations of our country join us in this mission. We are willing to support you with more webinars. We are willing to train doctors to conduct training sessions on this subject, and we are willing to be the torchbearers and to lead this initiative. I am sure that you will all benefit from this wonderful session by my esteemed colleague, Advocate Mr. Mahendra Kumar Bajpai, who is a leading authority on medical laws. Over to you, Mr. Bajpai.
Thank you, Ravi, for those kind words.
Can I share my... Is my screen visible?
Yes, it is.
It is moving?
Yes, it is.
Fine. Dear doctor friends, very good afternoon. Ravi sir has already laid down the premise of today's interaction. A doctor's legal right, protection from police cases. And when we say police cases, we are referring to cases of medical negligence. Friends, one very fundamental clarification. Sorry, I think I have... Give me a minute. Friends, a very fundamental clarification before we move to the topic. And the clarification is that today in India, doctors are criminally liable for medical negligence. We all know that the criminal laws of this country was changed in 2023. The Indian Penal Code, the Evidence Act, the Criminal Procedure Code, which were made by the Britishers, they have now been replaced by Indian laws. The Indian Penal Code 1876 was replaced by Bharatiya Nyaya Sanhita 2023. And when these laws were being made in the parliament, when the bill was piloted by the government, the then Home Minister, who still happens to be the Home Minister of this country, he had said in the parliament that we are decriminalizing medical negligence. Although this statement was made in the parliament, nothing happened thereafter. And the law remained as it was. So doctors are liable. Let this confusion go away, if there is any, for medical negligence. In fact, under the new law, there has been a small change which has come about. Under the old law, imprisonment was mandatory if a doctor was found negligent. But under the new law, it is just not imprisonment. A fine also has to be levied by the court if the doctor has been found negligent. So friends, with this introduction, we go straight to the topic. What is negligence? We will not delve into that. Very simple. When a person is careless, when a person is not diligent, we call him negligent. It is a wrong, and it invites both civil and criminal consequences. So a person can be sued for negligence under the civil laws. The party that has been wronged can ask for damages and compensation. And the wronged party can also go to a criminal court and seek imprisonment of this wrongdoer. The most interesting part, as far as criminal law is concerned, is that for this crime, there is no negligence. There is no intent. Friends, by definition, negligence does not have any intention. And therefore, the moral fault is absent. Otherwise, in all crimes, the intention to do wrong must be there. In negligence, there is no intention to do wrong. The wrongdoer does it innocently. It's just carelessness. But public policy demands that the wrongdoer should be punished, and therefore negligence is a wrong that invites both civil and criminal consequences. Friends, what is the difference between civil and criminal liability? Very simple. Ordinary medical negligence will not invite criminal liability. Criminal liability is invited only when the negligence is gross, it is reckless. Otherwise, there are civil consequences. The patient can go to a civil court. Patient goes to a consumer court, which today we see 99.9% cases go to the consumer courts. And the patient can also go before the regulator. Earlier it was MCI, now it is the National Medical Commission. So for all types of negligence, patient can go before a civil, consumer and a regulator. But only in cases where the negligence is gross, where the negligence is reckless, the patient has an additional one more forum to go, and that happens to be a criminal court. Friends, today patients are going to consumer courts. I've shared that with you. In consumer court, only those patients can go who have paid some consideration, who have paid some fees. So at least the doctors who are practicing in 100% charitable hospitals, government hospitals, they cannot be sued before a consumer court. But as far as criminal liability arising out of medical negligence is concerned, there is no place for fees. Whether the patient has paid fees, not paid fees, whether the patient is in a private hospital or a public hospital, all these patients can sue doctors for criminal medical negligence. Friends, criminal liabilities, there are many sources. Bharatiya Nyaya Sanhita is there, the new law that has come under section 1061. Criminal medical negligence is punishable, and earlier it was section 304A of Penal Code. There are certain other laws also which are dealing in medical domain, such as PCP/NDT Act, MTP Act, Transplantation of Human Organs Act, even the recently made Art Act and the Surrogacy Acts. There are provisions very clearly laying down criminal liabilities. And these are the provisions which are applicable to doctors only. So there's only one small thing that you should remember, that criminal liability arises only from a written law. So only when a parliament or a legislature makes a written law and prescribes that for doing this wrong, there is a criminal liability, a person can be sued under the criminal laws. Medical negligence has not been criminalized. Doctors can be sued under Bharatiya Nyaya Sanhita, section 106(1). I have already shared with you. There are some offenses, friends. Doctors in this country have not been sued for these offenses till date, at least in the criminal courts. Falsification of account happens to be a crime. Giving inflated bills, giving false bills, fabricating records also happens to be a crime. I have already shared the caveat that till date, no one has been prosecuted for these offenses. But this does not mean that in future no one would be prosecuted. Be careful. Friends, today's webinar, very specifically as laid down by Ravi sir, is on Jacob Mathew's case. In this case, which was decided in 2005, Supreme Court of India has given each and every doctor of this country three invaluable rights, three invaluable protections, three invaluable privileges in cases of criminal medical negligence. Friends, as you may be knowing, the law laid down by the Supreme Court of India is the law of the land. Everyone has to follow it. Very briefly about this case, there was an old man in Punjab, a town in Punjab, terminally ill, but his sons, who happened to be influential, that is what even the Supreme Court says, wanted him to get treatment from the hospital. The hospital also told them, the treating doctors told them, take the old man home. He is in his final stages, but they wanted the old man to be treated in a hospital. On that unfortunate day, Dr. Jacob Mathew was there. The patient had some respiratory problems. Dr. Jacob Mathew came, and this incident is of 95, when oxygen cylinders were used for providing oxygen. So there was an oxygen cylinder in the room. There was some malfunctioning. That oxygen cylinder did not work. The second oxygen cylinder in the room was empty. Dr. Mathew, he asked for a third cylinder. By the time the third cylinder could come, the old man had started the long journey. He was dead. The influential sons, they sued Dr. Jacob Mathew, both in the consumer court as well as in the criminal court. They filed an FIR and he was charge sheeted. Dr. Jacob Mathew, who challenged his prosecution right from the lower court, that is the magistrate courts, and the matter was taken till the Supreme Court. In Supreme Court, this matter was listed before the then Chief Justice of India, Justice R.C. Lahoti, and a constitutional bench. They decided this matter. Unanimously, they gave fantastic protections to doctors in cases of criminal medical negligence. Friends, before we proceed further, let me very quickly share with you some fundamental aspects which will be required to understand Jacob Mathew's case. Number one, where do we initiate criminal proceedings? If you want to file a complaint against another person for a crime that that person has committed, where do you go? We all know we go to police station. But if the police station does not hear us, what do? We go to a higher police officer, and he may direct the police station to register the complaint. This is one way, a police complaint. There is another way in which one can initiate a criminal proceeding, and that happens to be a private complaint. The complainant can straight away go to a court, a criminal court, and initiate criminal proceeding by filing a private complaint. So friends, there are two places where criminal proceedings can be initiated. One happens to be the police station, the other happens to be a court. In police station, by a police complaint; in a court, by a private complaint. Now, this learning, or rather this explanation, was important because the Jacob Mathews case has protected you at both the places, police complaint or private complaint. You are protected. This is what the Supreme Court says, and I'm quoting from the judgment, how doctors are protected in a private complaint. I quote, a private complaint may not be entertained unless the complainant in all criminal medical negligence cases happens to be the patient, has produced prima facie evidence before the court in the form of a credible opinion given by another competent doctor to support the charge of rashness or negligence on the part of the accused doctor. So here the Supreme Court is saying that if the patient goes to file a private complaint in a court, a criminal court, ideally the court must ask the patient to first produce an opinion by another doctor, a credible opinion. that points out to the negligent conduct of the doctor whom the patient is accusing of negligence. There is some dispute amongst lawyers, even amongst courts, whether this provision happens to be mandatory or not. But let us leave aside. The second protection happens to be the most important one. Friends, before 2005, the patient simply used to walk into a police station, file a complaint. The police used to come and pick up the doctor from the clinic, from the hospital, registered, finished. That is not possible now. The Supreme Court has laid down stringent conditions that the policeman has to follow. You doctors have to do nothing. The policeman has to follow that procedure in case of a criminal medical negligence filed by a patient against a doctor. I am quoting, let us read what the Supreme Court has said. The investigating officer should, this is compulsory, no ifs and buts, before proceeding against the doctor accused of rash or negligent act or omission, obtain an independent and competent medical opinion, preferably from a doctor in government service. So the responsibility to get a medical opinion is now on the police officer, neither on the patient nor on the doctor. Before the policeman decides to proceed against the doctor, the policeman has to get a medical opinion, independent one, from a competent doctor. And as we go further, we will see that the Supreme Court has left nothing to the discretion of the police officer. Probably they were knowing how police in this country acts. So what is it they say? Let us go ahead. Preferably from a doctor in government service, qualified in that branch of medical practice. So the doctor before whom, or the doctor whom the police officer should be approaching, should be a doctor in government service. Much more than that, that doctor must be qualified in the same branch of medicine. So if a hematologist, the complaint is against a hematologist, the policeman will have to go to another hematologist to get opinion, and that hematologist must preferably be in a government hospital, or rather a government service. Now the court has also prescribed some duty on the person giving medical opinion, on the doctor who has been approached to give medical opinion. And that duty is that this doctor who is giving expert opinion, medical opinion, must give an impartial and unbiased opinion, number one. This doctor must know Bolam's law, and he must apply that Bolam's law to the facts of this case. And this doctor must have all the evidence that has been collected by the policeman in front of him or her before giving this opinion. So, fantastic protection. Some stray incidents do happen where the policeman just don't follow this law. Stray incidents. But all those of you who have been practicing before 2005 will agree that the incidents where the policeman used to just walk inside and arrest the doctor has finished. 1 in 10,000, 1 in 1,000, these incidents happen because of this protection, friends. Police officer has been asked, before you proceed against a doctor, a mandatory duty is cast. Go and take a medical opinion from a doctor in government hospital of the same specialty as the doctor accused of negligence. Go and give that doctor all what you have collected in evidence. And that doctor who is giving opinion, he must give an unbiased opinion. He must apply Bolam's law. He must look into what facts have been collected. What is the evidence before him? Fantastic protection, friends, and you all should remember this. There is no need to be unnecessarily bothered about, stressed about policemen. You have a fantastic protection. Friends, I am a student of comparative law. No other jurisdiction, no other country has given such fantastic protections to doctors. In our country, not even member of parliaments have this protection. You will be surprised that a member of parliament or a member of legislative assembly has some protection. And the protection is that if the policeman wants to arrest that member of parliament or legislative assembly, he has to take permission from the speaker. Maximum time that has been taken by speaker is 3 or 4 days. But here, at least 6 months, is the time that the policeman takes to get a medical opinion. And there are n number of cases where the policeman has not been able to get a medical opinion. This is a fantastic protection that you enjoy. In fact, the third protection which has been given to you is from arrest. And this is what the Supreme Court says, does not need any explanation. Let us read it. A doctor accused of rashness or negligence may not be arrested in a routine manner simply because a charge has been leveled against him, unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigation officer feels satisfied that the doctor proceeded against would not make himself available to face the prosecution unless arrested, the arrest may be withheld. Don't arrest a doctor in a routine manner. This is what the Supreme Court is saying. Friends, clarification. These 3 protections are available to you only in cases of criminal medical negligence. If you are accused of any other crime, these protections are not available. Number 2, these protections are available to all qualified doctors, not just allopaths, Ayush doctors, dentists, everyone gets this protection. Now, whenever patients, locals, their relatives, the attendants, they try to threaten police action, or a policeman comes down and tries to harass you, threatens to arrest you for medical negligence, show that gentleman this judgment and tell in very clear terms, we are protected. What you want to do, you do in accordance with law, and we will face the consequences. So one thing, every doctor should keep a copy of this judgment in his clinic, home, hospital. I will not say in a car, but certainly wherever you visit, you must have a copy. Immediately after this webinar, all of you will get the copy of this judgment downloaded from the Supreme Court. Read it once. It's good reading also. Fantastically, His Lordship Justice R.C. Lahoti has laid down why these protections must be given to doctors. So do keep a copy of this judgment and do not hesitate to produce it before police if they are acting illegally. Friends, so no need to be over nervous, over anxious. Okay. In fact, you may be attracting the penal provisions under section 1061. When you are driving a car, the possibility of you inviting this section is hundreds or 1,000 times more. Then when you are giving medical services, there are 4 stages, in fact, of the criminal procedure. The first one happens to be when an FIR is lodged. Criminal medical negligence is a cognizable offense, so an FIR will be lodged. The criminal procedure is set in motion. Police then investigates and thereafter files a charge sheet. After that, a trial and judgment takes. When a patient approaches the policeman has all the liberty to file an FIR. The policeman has all the liberty to investigate. So the policeman can come to your clinic, can come to your hospital, collect evidence, which basically would mean medical records or maybe syringes, etc. They may try to take, that's fine. After that, they cannot file a charge sheet till the time they get opinion from a doctor pointing out to your negligent conduct. So FIR is filed, someone will be coming and saying, we have filed an FIR against you. You need not panic. You have Jacob Mathew's protection with you. Two very important tips, friends. Have excellent personal relationship with your local police officer, your beat officer. It helps. And as far as associations are concerned, you must engage, you must empanel a lawyer practicing in your district court. One thing which I have seen is that most of the associations, they want to engage lawyers who practice in high courts and supreme courts. That will not help you. Someone who is practicing in the local district court, he will certainly be of great help to you in your legal problems, especially when the policeman is involved. Friends, we run a Archana Sharma MedLegal Helpdesk. You need any legal aid and advice on criminal medical negligence cases, we are there. Those of you who are there in some medical societies, hospitals, medical colleges, doctors group, if you want to hold these webinars, we would be providing speakers. And those of you who want to further train your peers, we do conduct train the trainer programs for them. Friends, thank you. Thank you for listening patiently. If you have any questions, I would be happy to answer them. I'm done.
Thank you, sir, for that wonderful session. I'm sure everybody would have gained a lot from the session and the way you have explained this so wonderfully. We do have a few questions, and I will be raising each question one by one. Let me start with the first question, and this comes from Kirtana Chalamala Sethi. I'm sorry if my pronunciation was not very correct. The question is, what is Bolam's law? If you could just explain that in brief, please.
Very simple terms. Bolam's law is the law that sets the standard of care as far as medical practice is concerned. In the most simplest of simple terms, it means that a doctor who is following medical science, a doctor who is following medical practice that has been practiced in your area is not negligent in the eyes of law. It goes further to state that there may be X number of options available, but if you have followed any one option that is acceptable to medical science, you are not negligent in the eyes of law. This is in very simple terms, Ravi.
Thank you for that, sir. The next question comes from Somi Krishnamurthy. Is the State Medical Council empowered to consider complaints of medical negligence, or it should confine itself to ethical wrongs?
See, the problem here is what is ethical. The definition is very broad. Okay. So generally, medical council should be dealing with disciplinary actions. But what happens is anything goes wrong, the patient files a complaint before the medical council, and the medical council gives its verdict. So ethical, non-ethical does not work here. Ideally, they should be confined to, professional misconduct. That's the right word. But then everything comes under professional misconduct.
Fine.
Yeah, Ravi, I'm done.
So I'll move on to the next question. This comes from Dheeraj Roy. May I request you to define the competence authority a little? Is it a medical board of specialists or individual specialist is enough?
Ravi, where does this competent authority come in between?
I myself am not very sure.
There is no competent authority. Okay.
Yeah. No, and then again,
I think when we open the house,
no, competent authority mixing it with medical
when we
board of
open it, we
specialists.
can ask him to explain where he's from. Ravi, when we open this discussion
Sure.
for others to ask questions, we can ask him to put his question there. Yeah.
Sure, we can do that.
Yeah.
The next question again from Somi Krishnamurthy. If the relatives of the patients file a complaint of homicide in the event of interoperative death, section 299 IPC, then what happens?
See, homicide complaint can't be filed because a doctor never has an intention to kill someone. Whether it is homicide, you call it murder, you call it by whatever name, their intention has to be there. A relative filing a complaint against a doctor for homicide, it would be thrown out.
Fine, perfect. Thank you so much. Dheeraj Roy, for a doctor on government duty against whom an accusation has been made, is it mandatory to refer the case to competent authority of government sector only?
For a doctor on?
For a doctor
Could you
on
repeat the
government
question?
duty against whom an accusation has been made, is it now mandatory to refer the case to a doctor from the government sector only?
See, two things. We are talking about criminal medical negligence. So irrespective of whether the doctor is on government duty or not on a government duty. Okay. If it is criminal medical negligence and a complaint has been filed, then if a police complaint has been filed, then there is nothing like a competent authority. The police investigate, and that matter, the policeman has to go and take an opinion from another doctor who is in government services and of the same specialty. It is as clear as that. There is no competent authority as far as criminal medical negligence cases before the courts are concerned.
Perfect. Thank you so much. The next question comes from Mr. Manohar Reddy. Does a doctor have the right to choose to treat his patient?
Absolutely. You can say no to a patient simply because you don't like the color of his shirt. You don't like the way he has walked in. Any damn reason you can say no, except for religious purposes. You cannot say no. So you have religious differences, you can't say no to a patient. Save and accept that for everything, you simply can say a no to patient. You have all the rights to say no to a patient.
Perfect. I think what you mean to say is if the patient is not following your instructions, or if he is not really serious about the treatment.
No, Ravi, I am saying I don't like the color of the shirt. When the patient walks into my clinic, I can say, you get out, I am not going to, I don't want you to consult me. It's as good as that. No reasons asked.
Okay, I take it, but I don't think that would be the right answer, but still, I'll go ahead with that. Okay, now the next question comes from Dheeraj Roy. Do the police authority require permission from the head of the office to arrest any on-duty doctor?
No, no such authority is required. No such permission is required.
Okay. Next question again from Kirthana. What is the punishment for a patient or their attendees for abuse on duty doctor, and how can we approach for justice against such abuse at workplace?
So most of the states in this country have laws which prescribe punishment for patients and their attendants if they take law in their hand. If something like this happens, you should go to the nearest police station and lodge a complaint.
Okay. And the next question from Kirtana is, till what time after medical care is given can the patient file a criminal or a civil charge against the doctor?
See, for criminal charges, there is no outer limit, but it has to be filed as quickly as possible. For civil cases, it's 3 years, and for consumer cases, it would be 2 years.
Perfect. Thank you so much. The next question comes from Mr. Abhishek Reddy. If an orthopedician does a plastic surgery procedure and failure happens, is there any punishment? Or any procedure can be done by any doctor because in MBBS covers all basic knowledge?
I don't know how orthopedic surgeons can do plastic surgery, and then what will the plastic surgeons do? But anyway, this privileging happens to be a big cause of concern in India. Who can do what has not been clearly defined, described. Okay. Work needs to be done on this aspect, but certainly a orthopedic surgeon cannot do plastic surgery. Giving first aid is a different ball game, but performing a plastic surgery certainly is not permissible, according to me.
And the next part of the question, any procedure can be done by any doctor because MBBS covers all basic knowledge.
So then we should do away with all these specialities and super specialities.
Right. So at least I think if I can further elaborate on this, where facilities or where these specialists are available, leave alone the very rural basic areas, it cannot or should not be done. Would that be correct?
No, that won't be correct.
Okay, sure. We'll pass that. Next question comes from a known person, Dr. Pranesh Parmar. Can government doctor refuse to see the patient due to reason of overburden of work?
How can I say? I'm a poor lawyer. If the government briefs me, I will appear for them. If the doctor briefs me, I will appear for that doctor. And these would be departmental issues. So I don't think this is the right forum to ask these questions.
Okay, perfect. I think we have run out of questions. Mr. Agasti, sir, if you would like to open the voice just thing for anybody who has any other clarification or concerns, we can do that for 1 or 2 minutes.
Sure, sir.
We had
Participants, you can unmute yourself and ask the questions to Advocate Mahendra Kumar Bajpai.
You can raise your hands and we will take your questions if any are left one by one. Any further clarifications? Dr. Swapna, please go ahead.
So, good evening, sir. This is Dr. Sapna, and I want to understand, I mean, 2 points when you said that it is not permitted by a doctor to do a super specialty or maybe a specialty more than an MBBS grad is learning. I think it is permitted what Mr. Mangal said that if the competent doctor is not nearby and the doctor feels that it's an urgent and emergent requirement for that particular patient. So I wanted to put it across. And then second thing, while on the OT table, if a doctor sees some case, though he is not privileged, but privileged in that particular hospital, but he's competent to do the surgery, then probably with the help of involving 2-3 witnesses, the person, because they have opened this, the patient is already open on the table, then probably he can do the surgery if he feels it is important. I mean, I want your views on the same.
See, ma'am, privileging is a big issue, and today courts are flooded with these cases. Okay. You want to invite trouble, please go ahead and do so. Yes, if the patient is open, that's a different ball game. You have opened the patient, you want to do something for which you are not competent, you can do that. Okay, so no one is permitted to fly an aircraft, but when your pilot dies, there have been instances where ordinary people have flown aircraft and ATC have guided them.
Okay.
Yeah.
Thank you, sir. Anybody else, please? So I believe we are done with the session, Mr. Bajpai. Thank you so much for this wonderful session. I hope everybody attending this has been able to gain something out of this. And like I have shared earlier, we are open to doing more sessions as and when required. You can reach out to us and we'll be more than happy to oblige. Thank you, everybody, for being part of this session. Thank you, Mr. Bajpai. Signing off. Have a great